Clerk has had a few folks from our state reach out, so we'll want to.
Good morning. The Local Government and Municipal Finance Committee will come to order. Madam Clerk, would you please take attendance?
Chair Fitzgerald.
Here.
Representatives Burns.
Here.
Shannon.
Present.
Green. Present. Rogers.
Here.
Hill.
Here.
Hoskins.
Here.
Pies.
Present.
Zorn.
Here.
Paquette.
Here.
Bezat.
Here.
DeGold.
Here.
Preston.
Here.
Mr. Chair, you have 13 members. You have a quorum.
Thank you so much, Madam Clerk. I needed a motion to approve and adopt the minutes from our previous meeting. That motion is made by Representative Breen. Seeing no objection, those minutes will stand approved as written. No members absent this morning. Today we're going to begin with testimony on House Bill 4861, a bill by Representative Snyder. We'd like to first invite the representative forward. Representative, you can bring whoever you'd like as well to the table with you. And you may begin when you're ready. Thank you very much.
Good morning. Welcome back. Thank you, Chair Fitzgerald and members of the committee for having me this morning to take testimony on House Bill 4861. House Bill 4861 is a land conveyance bill. Simply stated, it grants permission for the County of Muskegon to sell a piece of property located at 97 East Apple Avenue in the city of Muskegon to Kids Food Basket, a West Michigan nonprofit. Kids Food Basket exists to increase access to healthy food for children and families. Their services include their flagship Sack Supper program, community farming, and food educational programming. They serve over 10,000 meals in western Michigan. Collectively, they are working toward realizing a hunger-free West Michigan. I'm joined here today by Muskegon County Administrator Mark Eisenbarth and Kids Food Basket CEO Bridget Clark-Whitney. They will both be able to help answer further questions and provide additional details. The need for an act of the legislature arises from the way the county acquired the land in question to begin with. In June 1996, PA 348 was signed into law, which allowed for the acquiring of state property in a land swap with Baker College. Fast forward to today, the property, which houses most of the non-criminal justice-related offices for the county, is needing major upgrades. Instead, the county used COVID recovery money to buy the campus of Baker College to move their offices. This is full circle, as the Baker College property is in fact the other piece of property that was part of the original land swap in 1996, which means they are vacating the Apple Avenue property described in the bill. The project, in a large sense, also represents an exciting opportunity to begin redevelopment and reuse the space of Muskegon County is vacating near downtown, unlocking tremendous economic growth over the next decade. We're actively working with DTMB and the county on a substitute bill which will be ready for committee to take up and vote in the next couple of weeks, and both the locals and state will be in agreement. Thank you for your time to hear testimony, and I'll introduce Mark Eisenbarth, Muskegon County Administrator.
Thank you. Good morning. And good morning, Chair Fitzgerald. This letter is to request your support and approval for House Bill 4861. The support and approval will allow Kids Food Basket, with its very important mission to create a greater, more accessibility presence in Muskegon County. Provide such needs support to children and families in our community. Access to healthy, nourishing food for the children and the family of Muskegon County is critical now for more than ever. Muskegon County ranks higher than the state of Michigan's average for children in high poverty neighborhoods experiencing in food insecurity and having limited access to fresh, healthy foods. The ability to have the permanent home for Kids Food Basket at 97 East Apple Avenue is vital to meet the needs in our community. This property is located in the city of Muskegon, which is near the public transit and will allow accessible locations for all. Kids Food Basket will make a location near a permanent home, allowing them to expand services to meet the increasing needs of Muskegon County. Muskegon County supports the mission of Kids Food Basket and strongly encourages the continuation and expansion of this important program within the Muskegon County to support the children and families with our community and to place them on a path towards the healthy future. I gave you a copy of this letter. You also have a copy of the letter from the city of Muskegon in support of this, as well as the public health in Muskegon County. Thank you.
Thank you. Good morning. Good morning, Chairman Fitzgerald, Representative, and the committee. We're really happy to be here today and grateful to Representative Snyder for introducing HB 4861 and presenting before your committee on behalf of this important legislation. At the core of our mission is the belief that healthy food is a right and not a privilege. We exist to break down barriers and increase access to healthy, nourishing food so that children and families in West Michigan can thrive. Through our flagship evening meal Sack Supper program, and our nutrition education and community-driven farming, we're bringing our community together with a shared goal of realizing a hunger-free West Michigan. This opportunity today is to request your support and approval of House Bill 4861, clearing the way for Kids Food Basket to purchase the property at 97 Apple Avenue for a future permanent Muskegon location for Kids Food Basket. We first expanded from Kent County into Muskegon County in 2012, and for 10 years we've operated out of a local church basement, where we started serving 389 meals at one Muskegon school. Today we're serving over 1,700 evening meals each weekday at 7 schools across the county. We also have 11 schools that remain on a wait list. We have reached the capacity to grow our food and nutrition programming in Muskegon. Currently, we're operating out of a temporary location in a coffee roasting warehouse. Last year, we moved into that temporary location, but we're seeking to acquire this property for a permanent Muskegon site. Access to healthy food for children in Muskegon is more critical than ever before. Some of our most recent data shows that 23.4% of our children in Muskegon live in high poverty neighborhoods. 17.4% of children in Muskegon are considered food insecure, living in homes where there simply is not enough food access. 40% of Muskegon children are over their BMI, and nutrition education is being required and requested from our schools more than ever before. Countywide, 17% of Muskegon County residents lack proximate access to healthy, fresh food. The acquisition of the former Muskegon County Health Department building at 97 Apple will continue to enable Kids Food Basket to significantly impact lives of children in our community. It will allow us to serve more meals, host learning-focused activities, engage our community in volunteer activities, and provide the necessary capacity to continue expanding our services to meet the increasing needs of our community. And lastly, I'll share, good food is the very foundation of good health. Good health is the foundation of a good future, and we're deeply grateful to all of you for this consideration. Thank you.
Thank you very much, all of you, for being here today. And while my committee members may prepare any questions, I'd just like to highlight, we have seen great work by your organization in Kent County in the 83rd District. While your headquarters is not there, we've seen significant impacts in addressing youth and child hunger, ensuring that there is quality food, quality access to food, and recognizing that sometimes getting your hands dirty also inspires a little bit of change in that diet to try new things, to experience new foods, and to round out your diet as well. And I am excited to see what you will achieve in Muskegon County as well, as I know that Representative Snyder has certainly seen a lot of benefit from your organization already operating there. So thank you so much for your testimony today. I have one question with regard to, really what, if any, revenue would there be to the state at this point? Is there any type of revenue associated with this for the state of Michigan?
So, as written, the money from the sale would go to the state general fund, as the bill. Now, working with DTMB right now on what that would mean and some changes that they would potentially like to the bill. But, that would be between the county and Kids Food Basket.
Evolving. Okay.
Evolving.
Thank you. Any questions from members? Yes, Representative Breen.
Thank you, Mr. Chair. Thank you, Rep. Snyder, for bringing this. Being from the other side of the state, I don't have a lot of knowledge of what's happening over there. So, but I do see that you have a good bipartisan bill. You've got some co-sponsors from some of your colleagues in the local area from the other side of the aisle, and I think that speaks volumes about how much this is supported. Chair Fitzgerald asked one question that I had, but I'm wondering, right now, is there any opposition to this at all? And if so, what would your response be?
So, in conversations with DTMB, the opposition would be ensuring that there's fair market value for the sale. And, you know, we're working on a substitute that would address that. But in regards to your first point, though, I would say that all members of the Muskegon County delegation, both sides of the aisle, are co-sponsors of the bill. So,
Thank you very much.
Representative Hill.
That's really fantastic. I actually ran a food program myself years ago, and it's such a joy to do the gardening and stuff. And we have a terrific program up in Ishpeming. We should put the two of you in a room, and the energy would just blow everybody away. So congratulations! I'm really excited to see that. I do have the questions about. We have a lot of state land in the UP too, and so I would. Maybe, Rep. Snyder, you and I could just have a conversation. I would like to further understand this because we have a lot of state land in the UP, and I know these kind of transactions come up, so I would like to understand that better. That's my fundamental question. Thank you.
Thank you, Representative Rogers.
Thank you, Chair. My question is regarding, so to be clear, is this regarding a restricted deed covenant?
So, and I can have Scott Hogan from Muskegon County's corporate counsel come up here.
Hi, I'm Scott Hogan, Muskegon County's attorney. It's a reverter clause in the deed from the state to the county so that if the property is not used for a public purpose, the state can, it's optional, but the state can come in and take the property back, which makes it really unmarketable. The county can't transfer it to Kids Food Basket, the way things are right now. So legislation is a way of trying to resolve that issue.
And what is the definition of public purpose?
It's a broad, it could be a broad definition. Generally, I think it can obviously municipal offices, a public park, a public golf course. There's also some decisions that say that public purpose is economic development.
Thank you. Yeah, I have a hard time with these. I had a hard time when I was a county commissioner. We had some restricted deed covenants in our county as well. I think this is a gray zone that I'm definitely open to, and I'm open to seeing what language you negotiate with DTMB, because I think while it's a private entity, it does sound like it's a public good that would be serving the public. So thank you for your testimony.
Representative Pies.
Thank you, Mr. Chair. So what happens when the Kids Food Basket decides they're not going to be there anymore? Do they sell the property and they get the profit then?
Want me to take that one? Yeah. At this point, we don't have any intention around scaling back our operations. If anything, as the future evolves, the operations would evolve to education and farmland, teaching kids about healthy, nourishing food and how to grow food right there. So there's one plot of 1 acre farmland right there as well that will be having nutrition education classes. So we work in conjunction with the schools. Like I said, we have 7 schools that we're working with now, 11 schools that are still on a wait list.
Right, but
Yeah.
that doesn't tell me what happens when it's no longer there. You
Yeah.
know, whether it's 25 years from now or 5 years, because that's not something you planned on, was to
Right.
not be there. So maybe somebody else could respond to that. I'm wondering if the county or the state then gets the funds from the sale.
Yes, I mean, if we sell it for a dollar amount, that dollar, does it come to the state is what we have to determine with the DMB, correct? So the idea, if we sell it for hundreds of thousands of dollars, they would own it at that point. So we have not discussed to have any type of reverter once they leave it back to the county.
So it depends then on how much money is exchanged for that, because it also, I guess, there's something I don't understand then here about a quit claim. I thought that's usually like $1 or something like that, just to go over. So I'm not understanding then what monies then would go back to the
So
state.
I'll just say, as written, the bill says that any money from the sale will go to the general fund. In conversations with DTMB, they would like language around fair market value, which, as I said, we're working on preparing a sub for that. But at that time, then, you know, the property would be sold for fair market value.
Okay. And is Kids Food Basket a 501c3?
We are.
You are. And are you affiliated then with any religious organization?
We are not.
Okay. Thank you, Mr. Chair.
Thank you, Rep. Breen.
Sure. Just a quick follow-up. I would agree with Rep. Rogers that this could very easily fall into the definition of public use. And so if you are making any changes to the bill, you might want to work on the scope of that. And in the event that Kids Food Basket was to decide to, maybe you just get too big for this parcel, maybe you have to expand, if you would maybe consider some language as to what would happen with the property then. Either it does go back to the county, it goes back to the state, or maybe it has to be sold to another nonprofit, just to make sure that this is something, a parcel of land that will be continued to be used for the public good. But I fully support this concept, and I wish you luck, and thank you for serving the kids.
Representative Paquette.
Thank you, Mr. Chair. Just a quick question around the process. I guess I'm not entirely familiar with this. Are there other properties with use conditions that are around the state? This legislation obviously just adheres to one, but has this happened before in the past? Is this something that I guess there's a precedent for?
Yes, I would say that. I know in Muskegon County in the past, there was a land conveyance bill for the former West Shoreline Temporary Correctional Facility after that closed and how that was conveyed. But there is a process for, you know, conveyance of land that the state has rights on. Last year, I believe we did something in Mount Pleasant. I don't know exactly. I was on staff, but.
Representative, we'll look into other examples for you and feel free to provide that to you ahead of next testimony on this bill. All right. Thank you all so much for being here. I just want to quick say, you know, clearly through the conversation and the testimony here this morning, there is a public benefit to having your organization in a community. Again, we have seen that in Kent County. We have seen that in a number of the school districts that you serve, the neighborhood districts that you serve, the children that you serve. The outcomes are evidenced. So thank you for bringing this bill forward. We will, again, be taking up additional testimony and potentially a vote here in the very near future as you continue to work with DTMB on that substitute. So thank you for your initial comments on this bill here today. Feel free to be dismissed, and I'm going to read in some cards now as well. All right. I have one card here from Neil D'Souza, who does not wish to speak, has a, quote, no position from DTMB. That is the only card here on 4861. So with that, we're going to go ahead and move on. Just one moment, please. I'm just going to move on. We'll take up 4860 now. Representative Menser. We do have an H1 substitute on the bill as well. With that, I need to take I will take a motion to adopt the H1 substitute for HB 4860. Motion made by Representative Breen. Madam Clerk, would you please call the roll?
Chair Fitzgerald,
Yes.
Representatives Burns,
Yes.
Shannon.
Yes.
Breen.
Aye.
Rogers.
Yes.
Hill.
Yes.
Hoskins.
Yes.
Pies.
Yes.
Zorn.
Yes.
Paquette.
Yes.
Bizat.
Yes.
McGold.
Yes.
Preston.
Yes.
Mr. Chair, substitute H1 is adopted.
Great, thank you very much. Now that we have the substitute adopted, I'd like to welcome Representative Menser forward. We also have with her Paul Gielahem, who will be testifying with her. Oh, let me confirm here. And I assume Jack Dolan as well. All right, thank you very much. You may begin when you're ready, Representative.
Thank you very much, Chairman Fitzgerald and all committee members. I appreciate you hearing testimony on this bill that will increase the transparency and good governance within charter townships. House Bill 4860 would allow officials in townships organized under the Charter Township Act to abstain from voting on a question when they have a conflict of interest. This bill is about allowing township officials to honor the trust their constituents have placed in them. Under current statute, a township official cannot abstain from a vote unless they are excused by the unanimous consent of the other members present. This can lead to a situation where a board member announces that they have a conflict of interest on a question and are subsequently required to cast a vote on that question. Under current statute, any one township official can deny another official the opportunity to abstain. A board member who believes the member with a conflict would vote in their favor can deny the abstention, legally requiring the member with a conflict to vote. Or a board member could potentially force a member with a conflict to choose between their personal interest, such as their duty to an employer, or the interest of their constituency. When an action by the board could benefit a member beyond that of a public benefit, their judgment could be impaired. Their constituency is not best served when the decision to abstain is controlled by other board members. House Bill 4860 would allow a board member who believes that a conflict of interest exists to abstain from that vote. The board member would also be required to disclose on the official record the factual basis for the abstention. This disclosure ensures that the community can be informed of the reason for an abstention and hold their officials accountable for choosing to abstain. In front of you is the substitute HB1 for the House Bill 4860. We have worked diligently with stakeholders to make sure that this bill does not conflict with other statutes that define conflict of interest and guide officials regarding when they should abstain. This sub is a result of the work, and the bill only changes the process that allows township officials to abstain. It also clarifies that the member abstaining should be in sole control of their ability to abstain. Other local communities trust that their elected officials will act with their constituents' best interests in mind. The decision to abstain from a vote when a personal conflict of interest could influence an official's judgment protects that trust. Such a decision should not be controlled by any other individual who could force a due process violation. Thank you for your time, and at this point, I would like to introduce former state representative and current Clinton Township trustee, Paul Gilliam, to offer some testimony, and then Mr. Dolan.
Well, members of the committee, Chairman Fitzgerald, want to thank Representative Mentzer for bringing this bill forward. Admittedly, this is not a huge sort of issue, but it is one that caused some pretty egregious situations. Having served where you are at and now down here testifying before you, this is an interesting experience for me. I do see some familiar faces up there. Representative Shannon from Macomb County, Representative Paez, who I believe graduated from the same high school that I did. Go Dragons, right? So basically, there's a line that I deliver often to my constituents as their local treasurer. I'm the guy who has to tell them that the rules apply to them the same as everybody else, and I can't waive them. So I say Clinton Township, like all local governments, is a political subdivision of the state of Michigan. So we derive both our authority and our responsibility from the state. And if the state says shall, then we have to. If the state says may, we have options. In this case, if a member who is a part-time trustee, for instance, who has the majority of her income coming from an organization, such was the case in Clinton Township, and the organization is out there lobbying on behalf of certain things, certain approvals within the local community, that member's, in a sense, placed in the position of having to decide Do I vote for my constituents, or do I vote for my personal interest? And in the instance where they try to abstain, it shouldn't be anybody else's decision to determine whether they have that opportunity, as Representative Menser suggested. This came up in our community, and I know that you often are placed in very difficult decisions. You have to decide what's in the best long-term interest of the state, what's in the best interest of my constituencies, what's in the best interest of these different groups, and you're faced with tough votes all the time. At the local level, I saw that look on the face of a colleague and said the law gives others the ability to determine if she can abstain for a conflict of interest. That's something that needs to be changed. Now, mind you, this is a small impact bill, but with, I think, some pretty severe consequences. It only affects charter townships, because if you're a city, this is covered in your city charter. If you're a general law township, there's no such provision in state law that says it's everybody else's decision as to if you can abstain or not. And so if you're a charter township, however, you're placed in that position. We had two people that believed that they needed that trustee's vote, and so they refused to allow her to abstain. That is a position that I think no elected official should be placed in. And so while I think you have a lot of issues that you're dealing with up here, this is one that is relatively small, but I think impactful. And so I appreciate Representative Menser for its introduction and the committee's time in taking it up.
And now, if you'd indulge us, we'd like to hear from Jack Dolan, Clinton Township Attorney.
Thank you. And again, we deeply appreciate your concern on this issue and your quick assistance on it. Mr. Chairman and members, my name is Jack Dolan, and I've actually represented Clinton Township since I got out of law school in October of 1977. So I've seen decades and decades of various township board makeup, and it's been my experience over those many decades that it will occur where, in fact, you encounter many what I'll call factions developing on boards. And many of you, I'm sure, have originated in your public service at the local level. And when factions occur, which is natural and happens quite often, generally the boards will respond on most mundane issues working together. But when difficult issues arrive, they turn inward politically. And to have something like this in the statutes is really a ticking time bomb, because what it does is it basically weaponizes a township board member to put another township board member on the spot and force, as Treasurer Gilliam indicated, a choice to, in effect, vote your conscience, which may actually be consistent with what your conflict is, or choose to vote against your conflict merely for the political expediency of showing everybody that you're not really going to act contrary to what to everybody in the public is a clear conflict of interest. And what I've seen in part, and I've heard many times, is elected officials say, I shouldn't have even brought up my conflict. You know, I've been put in this difficult position. It would have been better off for me just to vote what I thought was right and not introduce my conflict into the whole mixture. So this really does happen. I've been around a long time. I represent some other townships and cities. We don't have this problem in the cities because most of the charters either address the issues on ethics or some type of ordinance or policy addresses it. But here, we don't have a choice. We have to conform, as Mr. Gilliam indicated, to this state statute. And it really should be revised. It creates a situation that's untenable in trying to deal with constituents, because they just don't get it, and they just refuse to believe that something like this could exist, that you have to get permission from everybody to basically walk away and not vote on something that in most people's eyes would be a clear conflict of interest. So thank you.
Well, thank you very much for all of your testimony. I mean, clearly this has been evidence to me that this is not only necessarily a mechanism that we need to correct within statute, but is also something that is going to promote transparency and also ethical decision-making for Charter Township members. So with that, I would also welcome any questions from our group, as this is something that I think it does not affect my district and a number of districts in my area, but for the matter of fact, it's very clearly central to Clinton County's journey and what has brought you here today. My question is, there's clearly one situation that you're highlighting that has maybe sparked this this bill to be moved forward. But have we seen any other incidents within Clinton County or other counties throughout Michigan where this has been raised as an issue?
We're from Macomb County.
I'm so sorry. I said
I
Clinton
probably-
over and over again, didn't I? Macomb County. I am so sorry. How could I forget that my representative, a colleague here, is from Macomb County? I could never forget that. I apologize. So please.
I've seen it happen,
Okay.
yes. And as I indicated, it's in instances where it has happened, there's been a lot of what I'll call frustration expressed, both from the affected member of the board, who's now sort of caught in this position of having to vote when they feel that they've got a conflict that they've honestly disclosed.
Mm-hmm.
And I've also seen, as I indicated also, a lot of difficulty with the public accepting the situation that exists, because they just can't believe that you would be forced into voting in a conflict situation. But that's exactly what the statute provides.
And if I could add,
Go ahead.
so, Mr. Chairman, Macomb County now has an ethics ordinance. Clinton Township has an ethics ordinance. There's a new, I think, increasing, I think as more of the decisions that we make are out in the open, we have a 24-hour news cycle, people are paying attention all the time to everything that we do, there's a greater emphasis on transparency and ethics. And so, for a member to have to sit there and say, hey, if I vote yes, my constituents are going to think I did this because my employer was advocating in other communities on this same issue. And I was just feathering my own nest, so to speak. If I vote no, I'm actually jeopardizing my employment, because I know that even though I don't work in this specific area for the organization as a whole has supported this and is advocating for it in other communities. And so the best thing to do in that case is to abstain.
Well, and I'd like to remind my colleagues that we can abstain, we can pass without any explanation. When I was a Mount Clemens City Commissioner for 10 years, I was also a county employee, and a situation arose where I had to abstain because it would have affected my job. And I might have been enriched because of that. So I was allowed to abstain. I also abstained on something else. I happen to own, stock, wind turbine stock. Well, when we talked about renewable energy, I abstained because I could be personally enriched. So because the rest of us have the ability to abstain, you don't need to give a decision in appropriations or here in this committee to abstain or pass. I think it should be equal.
Thank you, Representative. Representative Pies.
Thank you, Mr. Chair. I think some of my questions have already been answered. So currently, if I understand correctly, someone can abstain and they don't have to say why they're abstaining. So this will change that so that they have to give the reason, and is that correct?
So currently, under the Charter Township Act, Representative, and thank you for the question, they have to request an abstention. And then it goes to a vote of the township board. The township board has to agree currently unanimously for that abstention.
Okay, and does,
They don't have to disclose the reason why. Since this removes, and basically the crux of this bill removes the mandate that there be a unanimous vote to allow that member to abstain. So since we're removing that provision, we're putting in a provision where the member would have to disclose the reason for the conflict.
and would the township attorney then have any say on whether legally it is in fact a conflict of interest, or if the person just doesn't want to vote for some reason?
The way it's set up now, there's no, what I'll call, ruling on the substance of the request to abstain, which I think is a good idea, because these situations appear somewhat impromptu often, and oftentimes in order to dig in and see if there's actually a basis for conflict, it requires an investigation and more information. And in our case, as Mr. Gillihan pointed out, we have a ethics ordinance. So if someone abstains and the grounds aren't appropriate, it could be a violation of the ethics ordinance. And in our case, with our ordinance, there is an appointed board against which a complaint could be filed. The matter could go before the board. It could be more fully vetted in that context, and a decision made on whether or not the abstention in this case was a violation of our ethics policy or board or ordinance rather, which is the place to do it, because to try to do it on the fly in the context of when the question to abstain comes up, there's really just, in my opinion, not sufficient time. It's too much of an impromptu decision-making process.
Thank you.
Thank you very much. Representative Breen.
Thank you, Mr. Chair, and thank you, Rep. Menser. I was recalling a time on City Council where we had a member who would recuse herself if there was even the slightest bit of impropriety, like if it was her uncle's, cousin's, brother's, former roommate, any type of connection, she would recuse herself because she didn't even want a hint of that. And there was a particular time where another colleague said, "No, there's no conflict. You should vote," which I thought was absurd. So just to be clear, with the townships, in order for somebody to recuse themselves, every single other member has to allow that recusal. Is that okay?
Correct.
Well, thank you for making an attempt to correct this, but
Charter Township.
Charter Township, sorry. And just, I see that the sub deletes the formal definition of a conflict of interest, and this is just for everybody here. I do worry about continuity of definitions at all levels of government. A conflict of interest at the city level, the township level, the county level, the state level. That is a heavy lift, and I'm trying not to look at the chair of our Ethics and Oversight Committee, because I'm sure that something's being worked on in that area. But what I do want to know is, does this bill and this procedure at all conflict with the conflict regulations for cities and counties? Just to make sure that there's continuity as much as possible as far as recusal process and abstaining from a vote at the city level or the county level.
I can speak with experience personally because we represent several cities when we've done so for over 3 decades. The city charters are the document which usually has provisions that relate to conflict. And oftentimes all that is really an enabling authority to then pass an ordinance that will further define conflict. In some cases, though, the charter itself will get more into the substantive details of what may represent a conflict. So really the cities are a little, as was indicated right at the onset by Ms. Menser, they're in a bit of a different position because they all operate under charters under the Home Rule Cities Act. And for the most part, the charter commissions that put together the charters work off of a model charter. And you'll see a great similarity amongst most of the provisions. So that's all addressed in a different format through the charter process. And And also, as I indicated, in some cases by ordinance with some further definitions. In this case, though, we do make specific, we were making reference to the, in the bill to financial interest and then also to violations of state or federal law or local ordinance as that might result in a conflict. So, and those are illustrations. I think with the whole concept of conflict, you have to be a little careful because you want to define it broadly enough to sweep up just about everything that you comes along, which most people would agree is a conflict. But if you start to get too expressive and think that you're covering everything, something will come along that you hadn't thought of, and you won't be in a situation to address it because your definition is too narrow. So that's just been my personal experience over the years, looking at that question of what is a conflict.
Thank you.
May I expand? Thank you. So, you know, as we worked with Rep. Mentzer's office to introduce the bill, as she indicated, we've reached out to a lot of the interest groups on this issue. And there was some concern that this would be used as an excuse not to vote on controversial issues. And that's a real concern. However, no city charter that we could find actually says, hey, it has to be unanimous vote of all your colleagues in order to allow you to abstain. That rule does not apply for general law townships. And so why does it apply to charter townships? It's this provision that, is out there. And so, yes, that concern is, hey, is somebody just avoiding the vote? So we tried to come up with this language that says, okay, let's define a conflict. And then we found out, and that's the difference between the sub and the original introduction of the bill, is it's very difficult to define what is and what is not a conflict. And so ultimately that's up to the member. And then ultimately it's up to their constituent to decide if they're just doing this to avoid the vote or if they're doing this because they got a real issue and they're taking the most appropriate action by not voting. So.
And I'm going to remind you that the official will be required to disclose their reason for an abstention.
Thank you.
Let me just quickly throw this in. In our case, we have provisions within our ethics ordinance where if you came up with what I'll call a precipitous, sort of phony reason, you could be in violation of our ethics ordinance. You could have a complaint filed against you. The penalties that we have, which could include, for example, removal from some of the subcommittees that the township operates under for in effect trying to duck a vote and using that as an inappropriate excuse. So there's mechanisms that go back to our treatment of ethics through our ordinance, where in our case that could be dealt with.
Thank you. We have two other members with questions for you all. Vice Chair Zorn, please.
Thank you. This brings back some memories when I was on the county board. I declared a conflict of interest, and it seems that every conflict of interest turns into a political argument. So it's a real interesting issue. But I have two questions for you. Number one, I think in this bill, the official has to state the reason, okay? But there's no vote by the board to approve it or disapprove it. That's correct?
Yes.
Under the bill, yes.
Yes.
We're removing that
Yes,
unanimous decision.
Right. And secondly, you're talking about, it's in the bill that this affects charter townships. What about general law? Is general law in the same boat that charters? Is it same law?
So thank you, Representative. No such provision exists in the General Law Township Act. So a person can just abstain if they're in the General Law Township and it's not a charter township. I guess I'll defer to.
They don't have to state a reason?
No, there's basically this section, which is 42.7 subsection 6, exists in the Charter Township Act. There is no parallel provision relating to conflicts or how to abstain that's set forth in the General Township Act.
Excuse me, Mr. Chairman. Just a follow-up, then does a city charter versus a general city, are they mixed in
The
with
city
this?
charters, like I mentioned, usually have provisions that relate to ethical issues and conflicts. They're baked into the charter that the Charter Commission presents and the voters approve. The model charter provisions that most cities actually take and use either without changing them or slightly changing them have sections that refer to ethical issues. But I can see you're a little bit surprised, and frankly, this whole area is very surprising because you've got this really strict treatment that exists in the Charter Township Act, and it's not even mentioned in the General Township Act.
Thank you.
And I think highlights the need for transparency. With that, I'd like to recognize Vice Chair Burns.
Thank you, Mr. Chair. Thank you all for your testimony today. My question has to do with a mechanism for potential deadlocks. So say you had a 7-member body, 1 member abstains from a vote due to a conflict of interest, and the remaining 6 members are deadlocked on a given issue or agenda item. What is the current mechanism in place to deal with that, and would that mechanism stay in place, or would it change if this bill were passed?
Well, I think assuming if all of the members were there, so all 7 members, 1 is abstaining, it still requires a 4-person majority to pass something. And so in the instance where they deadlock 3-3, the issue fails for lack of a majority.
Okay. Thank you. So that's current, and you're not looking to make any changes to that
Nope.
if this were to pass? Okay. Thank you. I appreciate it.
Seeing no further questions from the members here, thank you so much for your testimony to our esteemed guests from Macomb County. Thank you so much for your time and for your testimony. And we're going to be holding this back for probably another week before we vote on this or to bring this to the to recommend this. So please stay tuned. I do have one card to read in. This is from Judy Allen with the Michigan Townships Association, not wishing to speak, but in support of the bill. All right. Thank you so much. Appreciate your time.
Thank you.
With that, we are going to move on to our final piece of business before the body today, House Bill 4332. This is a Representative Whitsett bill. Representative Whitsett was not able to join us here this morning, but we do have Hassan Beydoun and I believe also David Bell from the city of Detroit with us today to testify in support of the bill. Mr. Beydoun, can you hear us in the committee room?
I can. Good afternoon, Mr. Chair and members of the committee.
You can begin when you're ready. Thank you so much.
Excellent. So this bill is relatively straightforward. It would essentially do 2 things. The first is it would allow for alternative service of process in cases where a city can't locate and serve upon or serve notice upon a property owner. So this is increasingly becoming a problem in Detroit, where we have a lot of absentee property owners, a lot of foreign property owners, and essentially we're just unable to initiate blight proceedings against them because we're unable to locate and personally serve them. So in those circumstances, so long as the city makes a good faith effort to try to find and serve notice upon that person, it provides an electronic alternative means of service over email and through the city's website. So that's the first change that the bill would make. The second is it would provide an enhanced penalty beyond what's provided in current law in situations in which a blight violator chooses to just keep paying the fines instead of actually fixing the underlying violation. So under current law, only if a blight violator refuses to pay the fines can they be hit with a misdemeanor penalty. This bill would add to that if a blight violator, so someone who has actually went to blight court, has been adjudicated against and found to be in violation of the blight code, if they, regardless of whether they pay the tickets, if they don't actually cure and fix the underlying violation in 30 days from that order, then they would be subject to a misdemeanor penalty. And this is, again, an increasing problem here in the city of Detroit because more and more property owners are just making the calculation that it's easier to continuously pay fines rather than actually fix their property and bring it up to code. So this bill would, by addressing both of those issues, really allow us to more effectively go after blight violators.
Thank you very much. That was a great explanation of what we have before us here. Do we have any questions from the committee here? So one of my questions pertain to the, kind of the expediency and the effectiveness of this notice of violation. With regard to good faith effort, that has really not been defined within the bill. Do you think this could lead to any confusion or any inconsistent enforcement with that good faith effort being left undefined?
I think that's a pretty common practice in statute to use the phrase good faith. It's become a term of art of sorts. And I think it's intuitive. You can ask 10 different lawyers, and I'm sure they'll give you 10 different answers in typical lawyer fashion. But at the end of the day, I think the common sense test here prevails, and ultimately what constitutes good faith is on a case by case basis. But I would view it as going through all the usual hoops that a city would go through to serve upon a property owner. But for whatever reason, that property owner is unavailable. So I think a good circumstance to illustrate would be a foreign property owner who has, maybe several LLCs as shell companies to provide a buffer between them and the actual property ownership. In circumstances like that, I think a good faith effort is essentially exhausting those options, providing notice on the property itself. And if the owner can't be reached that way, then I think the provisions in the bill would be triggered.
Thank you very much. Representative Pies.
Thank you, Mr. Chair. The current definition of blight, does that include anything like you've been keeping your car in your front lawn, or you have an RV in your driveway you just pay the fine every time, but it's still staying there for a year? Maybe you could explain to me what the definition of blight is and if it would pertain to something like that.
Sure, it's different for every city. The Home Rule City Act it provides certain categories of offenses that can constitute blight offenses, but it's really up to each city to do that. So it could run the gamut of everything from not mowing your lawn or improperly parked cars to habitability violations, much more serious violations. I expect that what you're getting at there is, would these enhanced penalties, would they cover someone who, repeatedly just doesn't cut the grass or something? And that's just not the case as a practical matter. It just, resources aren't going to be expended on that. And frankly, no, I keep in close contact with a lot of these administrative hearing officers in blight court. And those tickets would be tossed out immediately. I can't see any of those ever actually leading to enhanced penalties. It's really these really egregious cases that we're taking aim at. And I think, any other city that exercises this sort of authority would similarly take aim at.
Okay, thank you.
Thank you very much. Do we have Mr. Bell on the Zoom as well that would like to provide any additional comment?
Good afternoon. Thank you for the opportunity to speak. I would like to say that over half the residential properties in the city of Detroit are rental properties. Hundreds of property owners own 10 or more properties, be in the LLC or similar. And it's not uncommon for an owner to be out of state or out of the country and own hundreds of properties. Ticket posting on these properties are a complete waste of resources. If they post it on the properties, more often than not, the owner will not see the posting of that ticket. We spend hundreds of thousands of dollars on posting tickets in Detroit. For the continuing violations, there are a lot of people who will pay blight fines and correct the violation, and that's a good thing. Way more often than it should happen, property owners are ignoring the blight tickets and they thumb their nose when it comes to complying with blighted condition. And we believe that this bill takes a significant step in resolving both the ticket posting issue and continuing blight issue. Thank you.
Thank you, Mr. Bell. Excuse me, I turned up the volume here. Your audio was just a little bit muffled here in the committee room, but I think we got most of your comment there. I have a question from Vice Chair Burns.
Thank you, Mr. Chair. I think my question is best directed to Mr. Baydoun. So just looking at our notes on the bill, it's mentioned that the fines wouldn't apply to, quote, a government-sponsored enterprise, financial institution, mortgage service, or a credit union that would become a property owner after a foreclosure. What is the reasoning behind that? Because from my perspective, if a property has been foreclosed upon, likely it's facing some aesthetic challenges, if not structural as well. So just looking for some information on why that is the case and the reasoning behind that.
Sure. So I can try to speak to that. With the caveat that some of that is all of that really comes from existing law. So you have these exemptions, and those exemptions would equally apply to the new penalty under the bill that range from if the residence is or if the property occupant is a principal resident and they receive a PRE, they would not be subject to the enhanced penalties. But then you also have the institutional exemptions, like the one you mentioned, with respect to financial institutions and government-owned properties. And I think the rationale behind that was so this whole blight court structure was enacted, I believe, in 2013 or 14. So think post recession, all the foreclosure crisis. And so you had all these institutions that were coming into possession of large numbers of properties. And I'm guessing that there was a concern voiced when the legislation was originally passed that they would be in a scenario where they couldn't possibly monitor and comply on an individual basis when they receive those large groups of properties. And so I think that's where those exemptions come from. The principal resident exemption, though, I think is much more straightforward. It's just, we want to treat that very differently than other situations in which you have, an owner using a property as an investment property, for example.
Thank you. That answers my question.
We have two final questions. Representative Pies.
Thank you, Mr. Chair, for indulging me. A financial institution, is it correct then that a financial institution only under certain circumstances? And I ask this because I live in a city where there's a bank that's been closed for at least good 6 years, and it looks pretty horrible around there, and they keep paying the fines. So I'm wondering how that pertains, if it would be the same if it's the same for any institution that owns a closed property.
So I think a situation like that where you have, it's an extraordinary situation, right? That you're not running into this as a matter of routine. You just have one property that is really problematic. It's owned by a bank. There are alternative means of addressing that outside of the blight court scheme. Namely, you could do a nuisance abatement action. We've used that very successfully in those kind of contexts. But I mean, those kind of solutions really are one-off solutions. Like if you're talking, large numbers of properties, that's extremely impractical. But if it's just one in particular that's causing the problem, that you can use tools like nuisance abatement to get at that.
Thank you. We have a final question here by Representative Hill.
Very quick, I hope. I notice there's a footnote that cities with a population of 7,500 or more in any county. But I also hear about blight court, so I wondered, could you please clarify when does this apply to cities above 7,500 or not?
Sure. So it's a distinction made in existing law back in 2013 or 14, whenever this blight court scheme was enacted. And I think the rationale was just to give an option to larger cities that encounter these problems, and not wanting to paint with too broad of a brush there. Certainly I think it's for the legislature to determine whether or not that kind of eligibility should be expanded to other localities. But I think the way it sits now is just reflects the fact that these issues are less prevalent in smaller communities. And those alternative means of addressing the issues are more practical in those smaller communities, such that there's less of a need for this light court type of mechanism.
Thank you. Unfortunately, we have some decaying areas in some small communities where there are multiple properties, but this is, I'm glad these issues are being brought to light, and I look forward to learning more. Thank you.
All right. Thank you very much for your testimony today, Mr. Beydoun, Mr. Bell. We appreciate you joining us here virtually today. With that, I will take a motion to report House Bill, I have one card to read in. I have a card from Jonathan Green, not wishing to speak in support of the bill from the city of Jackson. So thank you for joining us today. Now, with that, I will take a motion to report House Bill 4332 with recommendation. That motion is made by Representative Burns. Madam Clerk, will you please call the vote?
Chair Fitzgerald.
Yes.
Representatives Burns.
Yes.
Shannon.
Yes.
Breen.
Aye.
Rogers.
Yes.
Hill.
Yes.
Hoskins.
Yes.
Pies.
Yes.
Zorn.
Yes.
Paquette.
Pass.
Bizat.
Yes.
Beagle.
Pass.
Preston.
Pass.
Mr. Chair, you have 8 yeas, 0 nays, 5 passes. House Bill 4332 is reported with recommendation.
Motion carries. So thank you all for joining us today for our first meeting back. We took up a number of bills to end the spring session before our in-district break that we'll probably see again here this fall. We will continue to address many of these issues that are facing our local municipalities, counties, and villages, townships, charter townships, obviously with great expediency. We have a lot of work ahead of us, and so thank you all for, again, today's work and for the work ahead that we will conduct here this fall. With that, and seeing no further business before the committee, this meeting is adjourned.